You're listening to an ECGI podcast on corporate power and the politics of change with Matteo Gatti.
There is a story we tell ourselves about capitalism, that it is a market system, that it runs on prices and incentives and the invisible hand, that whatever inequality generates is a natural result of talent and effort in an open arena. Katharina Pistor spent years dismantling that story. Her argument, made first in the Code of Capital and now extended in a new book, The Law of Capitalism and How to Transform It, is that capitalism is not primarily an economic system. It is a legal system, and the private law that runs it, contracts, property rights, corporate structures, is doing the redistributive work invisibly, transferring wealth upward while leaving citizens holding the cost. In my own book, I examine what happens when governments are too gridlocked to act and corporations step into the void, when businesses become, in effect, political actors of last resort. My argument is that this shift, what I call corporate governing, carries important risks. Corporations lack the structural capacity to address large-scale societal challenges, and relying on them to do so is both insufficient and potentially dangerous for democratic institutions. Pistor's book is what happens when you look underneath that dynamic. It asks, why is the legal system built this way in the first place? And what would it take to change it? I am Matteo Gatti. This is Corporate Power and the Politics of Change, an ECGI podcast. Stay with us. Welcome to Corporate Power and the Politics of Change, an ECGI podcast. I am Matteo Gatti, professor of law at Rutgers Law School, research member of ECGI, and the author of Corporate Power and the Politics of Change, published by Cambridge University Press. The book examines what I call corporate governing, the phenomenon of corporations stepping into roles traditionally reserved for governments. It takes two forms. One, which I call corporate socioeconomic advocacy, which is when corporations take public stances on contested political issues. The other is government substitution, when they deliver services or protections the state does not provide. In the book, I look at why this has happened, what the law says about it, and what the risks are, including the risk that relying on corporations to fill policy gaps ultimately weakens democratic institutions rather than strengthening them. Today's guest has written two books that I think best explain the legal infrastructure underneath those dynamics. The latest one, The Law of Capitalism and How to Transform It, is published by Yale University Press. Katharina Pistor is the Edwin B. Parker Professor of Comparative Law at Columbia Law School, the author of bestseller The Code of Capital, and a fellow of ECGI. Katharina, thank you so much for being here.
Thank you so much for having me. It's really a pleasure.
Let me start with the foundational claim of the book. Most critiques of capitalism are about outcomes: wealth concentration, environmental damage, stagnant wages. Your book is about the legal architecture that generates those outcomes. And the claim is not that law regulates capitalism, rather it is that capitalism is a legal regime. What does that mean, and why does it matter for how we think about fixing it?
So as a general proposition, I would say we always have to do a proper diagnostic before we can treat anything. So I'm not saying we can possibly really understand the root cause, because there will be not only one cause, but multiple causes. But I would claim that capitalism cannot be understood without understanding the legal infrastructure that it uses to constitute itself and to reconstitute itself over time. So very simply put, I believe that capitalism is a legal regime. Without the law, you could not possibly make credible commitments that are not bound by local communities, but that scale to national, even global level. You would not be able to protect investors from from liability for the damages that the companies they invest in might inflict on others, et cetera, et cetera. So there are lots of dynamics that you can look in to see that actually it it requires the law, even to set up a corporation, it requires the law to define property law. It requires the law to say what kind of contracts are enforceable or not. And without this, capitalism couldn't possibly exist. So at the very minimum, it's because of scalability. But on top of that, I think it also has to mobilize the consolidated means of coercion for enforcing the kind of commitments that are being made in capitalist law.
Great. So the book identifies 3 specific features of the legal system that, according to you, do most of the work. And I want to go through each one. One is expansion of legal personhood, and the other 2 are state enforcement of private power and legal arbitrage.
So I just want to clarify again, in this book, I'm talking about the system, not about capital as such. So there's a different dynamic for the micro-institutional creation of capital. For the system as such, I do identify the 3 features that I think allow capitalism to reconstitute itself, even in the face of regulatory intervention or other forms of trying to tame the beast and regulate capitalism. The first one I call private legal empowerment. So it does include legal personhood, but I think it also includes empowerment such as the protection of property rights, the sanctity of contracts, that is built into the private law regime, but it's also protected by most liberal constitutions today. So you have a double whammy here. And that also means that mostly individual actors, and they can be natural persons or legal persons, are empowered to use the law, take it into their own hands and create something new with it. And the law will enforce that. So unless you violate the law and the threshold is pretty high in private law, these kind of claims will be enforced. So that's number 1. Number 2 is access to the centralized means of coercion. So we very often associate the state with the institutionalization of the consolidated means of coercion, right? The state has the monopoly over the coercive power, one says. But what I want to add to this, that private actors have access to the means of coercion through litigation. And litigation, of course, can be done just to win a particular case. But if you have the resources and if you're playing the game in the long term, you're also litigating for the rules of the game. So you're trying to change some rules. And this is easier in common law than maybe in the civil law regime, but it holds there to some extent as well. You're trying to create rules that are amicable to yourself and to your own interest. You could also try to use contracts to make sure that others don't have the same access to the means of coercion. And of course, looking into the civil procedure rules that define who has the right to bring suits, when and how, and for what purposes is an important aspect of this. And then last but not least, probably most importantly, legal arbitrage basically is unavoidable in a legal regime because no law can be fully complete and anticipate all future contingencies. So there's always room for interpretation, and that room expands when you have frictions amongst multiple legal systems. So you have systems that are local, national, and global. You have multiple national legal systems that you can choose from. You have conflict of law rules or private international law that determine which rules might be applicable. And if you know how to play that game, you can actually make sure that some have the option to choose the laws by which they wish to be governed and others don't. And those that have the option, of course, have a comparative advantage over the rest.
Thank you. So I would like to come back to this when we talk about how to reform the system, which is actually where we're headed now. So the easy part of those who write about capitalism and inequality, in a way, is the critique, right? But your latest book goes beyond. And that's something that I find truly bold about the law of capitalism, is that you specify what type of reform we should embrace. And your, I think, unique contribution is that we've been mostly looking at the wrong tools, mostly in the public law realm. You say that a public law reform is naturally meant to fail because of, again, private law and its arbitraging attributes. So tell us about it.
Yeah, I think the starting point is really that in our Western legal systems, we have a duality of law. We have both public and private law, and I would argue this also holds in common law jurisdictions. So you have the law of the police, you have criminal law, you have regulation, you have constitutional law. These are the classic domains of public law. And then you have private law, which is contracts and property and business organization law, etc. So the beauty of private law is that it's malleable, that you can use it to also transact around legal constraints that are imposed on you by public law. And the claim that I'm making is that time and again, we've seen attempts by legislatures in different countries to constrain capitalism through public law. The biggest event, of course, was the New Deal in the United States, and I think it lasted quite some time. But it also was not immune against these arbitrage techniques that were used from the get-go to try to limit the effects of public regulations on private actors. So you impose capital constraints after World War II and you get currency swaps. You impose certain regulations on banks so that they are safer for everybody else. And then you invent basically shadow banking, which is doing banking outside regulated banks, et cetera, et cetera. So that is sort of what you have to understand of this dynamic. And in this dynamic, the first result that you might get if you think this through is that actually capitalism will always reconstitute itself. There is no exit. And that was my conclusion when I first started. And then I was trying to push it beyond that, because obviously if you can code capital and if you can use these legal devices to do different things, then you can also do stuff that is not necessarily capitalist. But what would it require? And I think we have to understand the logic of capitalism and also its normative foundations. And I've come to the conclusion that, first of all, we can't just abolish the law. Complex systems need a set of abstract rules. I'm also not someone who would say we have to abolish property rights or contracts. I think a fair amount of self-governance and decentralized decision-making is critical for complex economies, but it's also an aspect of freedom, of the possibility to self-govern. So I would also sort of assert this, and this can be debated, of course. But when you then think about how could you change these institutions, you can, of course, do this. You can have wonderful new designs, but with arbitrage, you can always get around it again. So the limit of arbitrage can only be a collective commitment to norms, because otherwise you can always arbitrage around. And so that's the leap I'm taking here, is somehow we have to reset the normative foundations of private law, which means not necessarily a complete change, because arguably there's already a lot in private law that can be marshaled for a different normative agenda. But some of the excesses of the way in which capitalist law has been used over the last decades in particular would have to be reined in and corrected. But a lot of this could be done in a fairly decentralized fashion. So I'm not saying run to Congress and try to pass a law, which is obviously impossible these days. But you can litigate to some extent, but you can also create new types of organizations. You can write different types of contracts. You can use the malleable private law to reorganize the economy bottom up in a fashion that at least makes alternatives viable, even if they will be at the beginning marginalized.
In fact, so if private law is the right domain for this work, you're telling us what a different private law would actually look like, because you're borrowing and organizing framework from two thinkers, Amartya Sen and Martha Nussbaum. They developed in somewhat different ways so-called human capabilities framework, and I'd like to spend some time on it.
Yes. So the question, of course, once you say we need a different normative framework, then you have to think about what kind of normative framework would be appealing to many people, because obviously many people would have to buy into that framework to make any change. So what we know from the long history of trying to engineer social change through law is that if you deviate too far from the benchmark of existing norms, you will not change anything, because people will stick to what they have. So you have to find a solution that allows many people to defect from where they are without really maybe realizing that they're defecting, or they're thinking this makes sense. That's why I chose the capabilities approach. Some people don't like it. It also has disadvantages. For me, it has a disadvantage along two lines. First, it is relatively close to our idea of individual rights, which is what some people don't like. But I think the nice thing is actually it will bring lots of people on board, because how could one disagree with the notion that every person has the right to live the life that he or she has reason to value? That seems to be pretty self-evident. On top of that, however, it has kind of a Trojan horse effect built into this, and that's what I like in particular, because if everybody wants and has the right to live the life that she has reason to value, somebody has to create the conditions for this to be possible. And this somebody is very often in our current understanding the state. So we go and ask something from the state. I want to create positive rights, and I'm not against them, but it's sort of basically the addressee is the state. looking closer, the state is, of course, part of the capitalist system. It's not really clear that the state will rescue us from the system. So I think we also have to develop claims against others that are not state actors, private actors, which include individuals, but also importantly include corporations, organizations, including those that might not be domestic but can be global. So there is, of course, a critique of the capabilities approach, because if you address too many who are obligated to do something, then maybe nobody feels responsible. But the beauty of it is you say, actually, you too, as a private actor, you are inflicting power relations on us, and you are not accountable to us in any way. You're actually denying us to live the lives that we have reason to value, and we have to find technique to rein you in.
So I have a curiosity. This system, you mentioned that chances are that it's not going to be adopted anytime soon by a legal regime. But for a second, let's assume that that is a vague possibility, right? So do you envisage a system of private law where relationships between business and individual citizens are governed differently than relationships among citizens alone and among businesses themselves alone? So in a way, that would resemble how in some parts of continental Europe in the 1800s, code of commerce covered different persons than civil codes. And is this an idea that you are, and it's not in the book, but I'm curious about how you see this panning.
So I wouldn't give companies a free pass to deviate from these norms when they deal with one another. I think we have to have this fundamental commitment. I would make very clear that capabilities are human capabilities. That also means that we limit the extent to which the capabilities can be extended to legal persons. So we can talk about how much legal persons should have the right to contract or own property. Even there, I probably would limit the extent to which we protect their property in comparison to humans. I would not give them the right to freedom of speech by spending money. I would not extend religious rights to them, etc., etc. So these are the classic civil rights, but if we go through the capabilities, there are similar. These are human capabilities, and these are the norms that we're protecting, and companies and organizations are also in the mission of protecting these norms and making sure that all humans have the possibility to live the right that they have, to live the life that they have reason to value. So in that sense, it's not an 18th century. The corporations, or the business people, they know what they're doing. We don't have to regulate so closely. We just have to do it for civil persons, natural persons. What I would suggest, and here I'm building in part on the work of Martin Hesselink, who had written a review of the Code of Capital early on, and he suggested to develop something like a just European private law code, you could say a just private law code more generally. So to inform judges what it would mean actually to interpret the existing private law in a way that is consistent with broader fundamental principles of justice. This could be the capabilities approach. This could be a different type of approach. I was a bit critical of this first because I'm not a great fan of soft codes. The problem is that they do too little, and typically people think they've done everything they had to do once they did it, so nothing comes out of it. But I think it could be a good starting point for this project to think through what a just private law code would look like, and also to find areas where it's actually already in operation, because some courts are already doing it. Others are writing new contracts or creating new types of business organizations that are fully consistent and they really advance these kind of principles.
Okay, so it would be again the Europeans going ahead with with regulating and see how the Americans react this way. I'm biased because
I'm saying in the book, not a European
right,
private law code. I'm basically saying we should have a general one and
right.
so make it accessible. I would also say in the US there are lots of areas, as you know, the Public Benefit Corporation, the Patagonias. There are many other. There are people who use the LLC of Delaware to create cooperatives. There's lots of stuff is happening on the ground. The problem is, of course, all these little things could fizzle out unless you kind of tie them together. And I think a common normative framework and maybe something like even a soft code that sort of foregrounds the principles on which these organizations rest and let others know that this is already happening might help us to expand the scope.
Absolutely. So I want to go back to legal arbitrage because you have a point here. Smart money and lawyers can frustrate policy action. Imagine we manage to close the carried interest loophole. Most likely, tax lawyers will find a way to go around it again. And by the way, we don't even have to have a lot of imagination. Whenever worker rights are expanded, businesses find ways to requalify workers as independent contractors, and so those laws don't apply. But then, how do we limit arbitrage without throwing the baby out of the bathwater? More mandatory rules or new canons of interpretation for judges? A sort of uniform substance over form, overarching doctrine, how or many separate intervention, and how don't we get trapped in more arbitrage once we try to abandon it?
Yeah. By having simple rules, red lines, and sort of the legal effect is no enforcement. Enforceability is the key, right? Making credible commitments also means I can enforce this in a court of law in the end. We don't do this all the time, but that threat, I think, is critical for scaling. And the rule is simply if you come to court with unclean hands, if you do things that are actually denying other people that are, are directly affected by what you are doing, deny them their capabilities in core areas of their life, then you cannot enforce this. So do whatever you want, but the law is not behind you. And, famous example, of course, is our speculative assets. The so-called wagers were unenforceable under common law, no criminal sanctions, no regulations, do what you want, but you can't ask the law to enforce your contracts. And in the 1990s, when derivatives markets started to grow, there was like this legal uncertainty. Can we enforce this stuff? Yes or no? And only in 2000, the US Congress passed the Financial Modernization Act and said, yes, you can, which is when these markets really went through the roof. This tells you something. It's really important for these markets. So I think denying enforceability at the back end will set some things right. Not everything, but it's a clear-cut rule. You don't have to, again, I'm saying regulation will not work. It's too complex. It's too slow. The private sector will know how to get around it. But if they invent whatever they want to invent and you say, well, fine, let's take a closer look what this means for what effect this has had, what negative externalities you're creating for others, this is not enforceable.
And in fact, you draw an analogy here in the book, sort of along these lines, with of all devices, the breakthrough rule under European takeover law, which is essentially you borrow from it and you essentially use it to sort of explain how to make all of this more as an operational way for judges to enforce. Can you tell us a little more?
Yeah, I mean, the struggle for in Europe, you can debate whether this takeover directive was meaningful or not. But I think if you think it's important for having a takeover directive, then you have to make sure that it works in the same way in multiple jurisdictions. And of course, lawyers realized very soon that different jurisdictions had different ways in which they could prevent mergers from happening, different ownership structures, different voting rules, different veto rights, et cetera, et cetera. So the trick that they came up with is, again, sort of it's just legal engineering, but I think it's kind of ingenious, is to say, if and when a takeover bid is on the table and at the next shareholder meeting that has to approve any defensive measures that exist, or if you make a decision about the merger itself, then the kind of defensive devices, whatever their form might be, will be made ineffective for the purpose of this particular decision, right? So this is, again, I think, a way in which they say, we can't standardize. So the European Union has sort of this, long history of harmonizing, and it will never be harmonized because it deviates again, of course, the minute that you have harmonized it, and it's political compromises that just take ages, right? But if you have something like that and says, actually, if you certain whatever you do in whatever way you might do it, but if it has this effect, it's not enforceable. That's the beauty of it.
And so I would like to move on and address another specific reform you suggest, because that again borrows from what we do for a living. We teach corporations and securities laws, and so one of your most concrete proposals is applying the precautionary principle to tort. Right now, the burden is on the victim, and you must prove causation, often against defendants who hold all the information. And you propose inverting that, where there's a credible risk of serious harm to public health or the environment. The plaintiff must demonstrate safety. So, the corporate actor must demonstrate safety. So you draw a parallel to securities fraud, where courts already adopted the fraud on the market theory because requiring individual proof or reliance was functionally impossible. You're saying, well, we know how to do this because we've done it. Why haven't we done it for corporate pollution or data extraction, where the harms are just as large, if not arguably now larger, and just as statistically demonstrable?
Yes, we have done it also in other areas. Think about product liability, right? Where courts in this country developed already since the 1960s strict liabilities because it was impossible for a consumer to locate where exactly the defect might have been, etc. So there's a long tradition for doing this and this is in the name of justice. You're trying to make sure that people, when they dispute and they are in court, they have similar weapons at their disposal. And if this is so uneven, I think the courts have long tried to balance this. And then at some point, they haven't done it to the same extent anymore. And I think it's part of our neoliberal ideology that we should just allow the markets to do whatever. But again, we can build on a strong legal tradition that actually has said, no, we want to actually have, when we mobilize our collective means of coercion, when we're saying you can use the courts to enforce this, then the courts should also have the power to say, under certain conditions, we will not do it, or we will do this only if you, the other party, can show me what's going on. And they have done this, in the common law, a lot through case law in the most continental European countries that required some legislative intervention. Of course, then we had the product liability directive in Europe. So there are different strategies to get there, but that should be the outcome.
And, along those lines, I want to go back. You mentioned earlier briefly the clean hands concept. So, we're going back to contracts. So, the book takes aim at the 19th century formalist view that contracts are freely negotiated between autonomous parties, freedom of contract, free markets. And so that fiction barely held then, and it is untenable now. Whenever we open our phone, we have to agree to 50 pages. We don't even know. It's endless scrolling, and then we have to say yes to do whatever. And that when you have a bank account, when you use a medical device, etc. And that's you revive the clean hands doctrine for it. What is the clean hands doctrine?
So I think in the origins, basically, if you want to have justice from a court of equity, you have to come with clean hands. You have to basically be, not the perfect person, but you can't have abused the law for your own interest, even if it's formalistically valid. Even today, you have the Chancery Court of Delaware, which is the major corporate law court in this country, and which is a traditional chancery court in equity. It says frequently, even though it might be formalistically legal, it might be compliant with the wording of the Delaware corporate law, it might be inequitable. And that's the fundamental principle here. So if you're trying to enforce something that might be formalistically legal, but it's inequitable, we will not enforce it. And so the doctrine of clean hands basically say, if you want to have these kind of remedies, you have to come with clean hands yourself. And I think that's a powerful weapon against particularly digital companies' uses of boilerplate contracts, which they can change all the time, which they also play to you in a way that you are very likely to click agree, which we all don't have the time to read, and most people won't be able to fully understand. So if you said, actually, guys, this is not binding, and if you're trying to hold the line here on these issues, people can walk away from these contracts and you can't hold them liable, you're changing the dynamics in a quite fundamental way.
Right. So I want to end with a harder question, and the one that I guess that asked a lot when I present work with prescriptions attached, and that's the feasibility of reform. I know that we briefly mentioned it before. I know you said that it's not realistic now, but I want to talk about it in any event because this fascinates me. Because my book shows that congressional gridlock and political dysfunction are among the key drivers pushing corporations into the governing space. The structural barriers are real. There's polarization, filibuster, counter-majoritarian features of the American constitutional system. And so if reform in general is politically impossible, why should we expect private law reform to be any different? Especially since lawyers are those who will be impacted the most.
Because the channels are different. So if you think about changing the law, maybe adopting a federal corporate law in this country or doing any other thing, so procedure reform, etc., it requires Congress to act or state legislatures to act. And state legislatures also have been actually captured by the private sector. So I'm not sure I would only say, the private sector is doing governance because the government is dysfunctional. I would also say the private sector has always tried to impose the logic of private law onto government. And I think this has gone pretty far in the United States. But my point is that private law could also be used for something else. And because it is a legal framework that can be used in a decentralized fashion, I can set up a company and do my business in a way that is compliant with certain normative principles that nobody can challenge. If I play roughly within the game of the law, of course, I have to find my financial resource, I have to find my business partners. But the more that people do these kind of things, the more viable this becomes. There will be some bottlenecks. Of course, if you cross the more powerful ones the wrong way, they might try to enjoin your activities or try to contract, again with you or try to buy you up and whatever they might do. But then you have to find ways to protect you. You have to apply defensive measures, etc. In a heads-on litigation, it's not going to be easy. A couple of things that I would say, I think lawyers are wrong in going for settlements with big companies and big tech. They should never go for settlement. They should push for a final judgment and get a ruling to change the law. So lawyers are of course part of the problem because they're playing the game of making a lot of money too, but not all lawyers. There's always been civil rights lawyers. There have always been those on the other side. There are lots of lawyers who left the firms that kowtowed to Trump last spring. I think there's a sufficiently large number of lawyers out there that could do it differently. And I think one of the reasons one teaches is to teach lawyers that there are alternative ways of doing things.
The book ends on a note of possibility, but we're recording this in a moment when the political winds are blowing hard in the other direction. Does the current moment make you more pessimistic, or do you see openings?
So it's not easy to be optimistic in the current moment, obviously, whether it's the climate change, our failure to address this, of course, the rising number of wars around the globe. So it's hard to be optimistic. Also, the political situation in many countries is fragile. But I tend to be an optimist nonetheless about human capacity to find solutions for themselves and also to have empathy for others. And there are lots of examples that we could also pull out, whether it's Minneapolis or other places where actually people who might not have had an opportunity to show their empathy under normal circumstances in times of crisis come out with this. So in some ways, you could always say, major crises are very often the incubators for change. And it might be paradoxical, but this is maybe also the times when more and more people are coming to the conclusion that the system that we have is no longer tenable and we have to find for solutions. So for me, as somebody who's thinking about system transformation, it's also the time where we have to show that there are viable alternatives. We can't predict whether they will be taken. We can't really guide a complex system, but what we can do is offer a whole range of possibilities that people can pick up. And then hopefully we can align them in such a way that we're saying we have a common normative threat that we want to realize. And here, let's try to do these things on the ground where we are most effective and see whether we can advance this agenda. So what gives me hope, I think, is when you look back into history and you think about, people who were trying to think about the post-World War II era in the middle of World War II, or earlier on, the people who thought about how the world could look like in a democratic Republican fashion under feudalism or absolutism. So, ideas matter and the world can change also, again, for the better. And so that gives me hope.
Katharina, thank you. This has been exactly the conversation I hoped it would be, and it was a true privilege to have you here.
Thank you, Matteo. It was really nice to talk to you.
So here's what I take away. We've been debating capitalism at the level of outcomes for decades, and Katharina Pistor is telling us that we've been arguing at the wrong level. The outcomes are downstream of the legal code, and if you want to change them, you have to change the code, the private law of contracts, property, corporations, and torts that most reform proposals never touch, all at once at least. My book asks what happens when the political system is too gridlocked to act and corporations step in. Katharina's book asks why the legal system underneath that gridlock is built the way it is. Together, I think our books reject the idea to expect more from corporations. It is by rebuilding the legal infrastructure that makes private power accountable. For listeners, The Law of Capitalism and How to Transform It is published by Yale University Press. My book, Corporate Power and the Politics of Change, is published by Cambridge University Press. Links are in the show notes, and this is Corporate Power and the Politics of Change, an ECGI podcast. Check the other episodes, and thanks for listening.